Hello, everyone. Thank you for joining us today. We're going to give folks a few minutes to arrive and then we'll get started shortly. Thanks to everyone who's joining for today's training. We'll just give folks a couple minutes to arrive and then we'll get started. Okay, it looks like a number of folks have been able to join us, so we'll go ahead and get started. Welcome to our MDLS training today on de facto parent custody. My name is Sarah Wittry and I'm the Pro Bono Program Manager here at MDLS. And a bit of housekeeping, any materials that come up today, we'll place them in the handout section of GoToWebinar. And we're also happy to take any questions as we go along. So please post your questions in the chat and I'll read them out loud. And we're lucky today to be joined by Michele Zavos. Ms. Zavos has almost 40 years of family law experience as an attorney in the DC area. And thank you so much, Ms. Zavos, for joining us.
Thank you. I'm pleased to be here. I have to say it's a little weird, audience, because I can't see any of you. I have no idea who's out there. So I'm sort of talking into the ether. But please do ask questions as we go along, and we will address them as we go along. Sarah will interrupt me and tell me about the questions. So, you know, in a way, I'm just sort of flying blind here. I have no idea who you are. I have no idea how many people are out there, nothing. So let me just tell you a little bit about myself. Sarah's right, I've been an attorney for 4 years, and sometimes you wonder, how did that happen? I have worked primarily in the LGBT community since 1982, when I joined a law firm as an associate. Most of my time has been in the District of Columbia in Maryland, and I was counsel on the case of Port versus Cowan, which the Court of Appeals found that a marriage between a same-sex couple had to be recognized for purposes of divorce. I have represented, you know, thousands of people in my career, and have been very intimately involved, I guess, in the kind of issues I'm going to talk to you about today. So again, since I don't know anything about any of you, I will assume that you do not know much about de facto parent. And so where I would like to start is the background of de facto parent and how we came to where we are with the elements I'm going to talk to you about today. De facto parent in Maryland, well, let me start with the definition. A de facto parent is someone who is not a, quote, legal parent, not by birth, not by court order, but by action. And that's really what we're going to talk about today. And this is, to a great extent, from the children's point of view. And when we get to the elements, we'll talk about it. So prior to 2008, Maryland had de facto parent by case law. But in 2008, there was a case, Janice M. versus Margaret K., and it was a terrible case. What had happened is Janice M. And Margaret were together for some period of time, same-sex couple. They decided to raise a child together. Janice adopted a child from India, and you know, back in those days, they certainly could not get married, and they could not adopt the child together while in India. Unfortunately, they raised the child, but they never did what we call a second parent adoption. And a second parent adoption is when one person already has a legal relationship to a child, but another person also becomes a legal parent through the process of adoption. And we started doing those in about 1993, 1994 in the state of Maryland. If it is an opposite sex person, if you have somebody who is acting as mother, the courts have no problem in having someone who is acting as father to become a legal parent. But in the time in 1993, 1994, same-sex couples were raising children, and of course they both wanted a legal relationship to their child. So we started doing the second parent adoption where the original parent, and generally this was a birth parent, maintained her legal rights to the child, and the second parent was granted an adoption so that she also had the same legal rights by rights of adoption. And I'm not going to go into all of the legal issues around there, but we do not actually have a higher court opinion. All these have been done in trial courts. But so they were available in 2008, but for whatever reason, Janice and Margaret did not avail themselves of this opportunity. So Margaret did not have any legal relationship to the child. And this case was litigated, and a very, very unfortunate case because Janice, the two women broke up. Janice would not let Margaret see the child, very much so turned the child against her. And the case goes to the Court of Appeals, and the Court of Appeals held that Maryland did not recognize an actual de facto parent or psychological parent relationship. And so that ended the opportunity for someone who was acting like a parent but did not have a legal relationship to continue the relationship subsequent to the adult relationship being ended. So that left same-sex couples who were not married, who did not have a second parent adoption, broke up, and the joke in the community that I serve is, for the most part, this is about a lesbian behaving badly. We call them LBBs. So at the breakup, the birth mother, or the legal mother, in Janice's case, she was the adoptive mother and sole legal parent, withheld any kind of interaction with the child that the non-legal parent had, even for many, many, many years. And this applies, of course, not just to same-sex couples, but people like step-parents. Could you have three people having a legal relationship to a child? Grandparents who are raising a child with the consent of the birth parents, who may later change their minds, and then the grandparents can't have any access to the children. So we had that until Conover, and Conover was in 2016. And it was a similar kind of case. These two women were together. They had a child. They raised the child. One of the women came out as transgender. They broke up, and the birth mother refused to let the other, now father, but for purposes of the case, he was a lesbian, refused to allow any access. So that case also goes to the Maryland Court of Appeals. And this time, the Court of Appeals says, actually, we were wrong in Janice M. versus Margaret K. And in fact, we are going to reinstitute a de facto parent possibility for people in these circumstances. And again, this is not just about same-sex parents. You can have a de facto parent, a step parent who has raised a child for many, many, many years, a grandparent who has raised a child for many, many years. So what the court then said is it's now possibility for somebody to prove that they are a de facto parent, meaning they have no legal relationship with the child, but they have a relationship based on action. And the court came out with 4 elements for this. One, that the legal parent, that's either a biological or adoptive parent, consented to and fostered the de facto parent once they are found to be a de facto parent. Formation and establishment of a parent-like relationship with the child. And of course, what does that mean? I mean, this is all factual, which of course, for those of us who do family law, we know it is to a great extent within a judge's discretion about whether the judge interprets these facts to create a de facto relationship or not. But it is things like, you know, medical care. I mean, there's another element that is much more specific, but from the child's point of view, the person is a parent. Whether they get called mommy or daddy or whatever, doesn't matter. The petitioner, this is somebody who obviously is challenging the non-access. The petitioner lives in the same household. One of the questions here with a child, one of the questions here is, does it have to be full-time? Could it be part-time? Could it be like a divorced parent? What? Then the third is that the petitioner assumed obligations of parenthood by taking significant responsibility for the child's care, education, and development, including contributing toward the child's support without expectation of financial compensation. Basically anything a parent would do, you know, sing the child to sleep, go to PTAs, I mean, all of those things, all the things that you can think of what a parent would do vis-a-vis a child would be part of this. And then 4, that the petitioner has been in a parental role for a length of time sufficient to have established with the child a bonded, dependent relationship, parental in nature. So if you take those 4 elements, what we're really talking about is sort of a totality of the circumstances that you can then break down. You know, one of the things is, of course, that the other parent has fostered and consented to that relationship. And so how do you prove that? Things like Mother's Day cards, leaving the child with the other parent, announcements. I mean, any case you have, you will be trying to gather all of those pieces of evidence, emails back and forth, notes, whatever, pictures from a school that a child might have drawn. So you're looking at everything that a parent would expect to receive or to do would be looked at for the de facto parent. Now, once you find, or once a court finds that there is a de facto parent relationship, the de facto parent should stand on the same level as the de jure parent. They're the same. They're both parents. And of course, I mean, in a way, you have to find de facto parent, you've got to have a judge in an order find that someone is a de facto parent. So there you go. I mean, that's the legal piece. Somebody can't just run around saying they're the de facto parent. It's going to have to be established in court. So going back to same-sex parents, what happens for same-sex parents now in the age of marriage equality, a lot of people do get married and then they have children. And again, for those of you who practice family law, if a couple is married and has children together, there is a marital presumption, which means that it is presumed that both parents are legal parents of the children. For same-sex couples, that's going to be a little bit different because unfortunately, there have been a number of cases around the country in which couples have broken up and judges have found that the non-birth parent, non-legal parent, is a third-party stranger because lesbians cannot together create a baby. But of course, we don't look at opposite sex couples and make a determination about whether someone could actually father a child. And it's estimated that at least 10% of children who are born into marriages are not the biological child of the husband. So for those of you who are representing same-sex couples as parents, it is imperative for them to obtain a second parent adoption. I've run across many lawyers who say, oh, well, they're married, you know, they're both on the birth certificate, we don't have to do anything. That's wrong. Just put it out there. That's wrong. And the reason it's wrong is that birth certificates by themselves do not create any sort of legal relationship. There is a Supreme Court case, I think it's EL versus VL, or it might be the other way. It came out of Alabama. There were two women who were in Alabama. Somehow they managed to do a second parent adoption in Georgia. I asked a friend of mine down there, how did that ever happen? And she said, don't ask. I said, okay, I don't want to know. But what happened is, of course, they break up. One woman won't let the other woman see the child. Goes through the Alabama state court system and eventually ends up at the US Supreme Court because the birth mother, the legal mother, says that the other mother did this second parent adoption. They did it together and it was fraudulent. The court said, nope, never mind. We've got a court order. So for full faith and credit, we give full faith and credit to the court order. We don't look behind it. So what that has meant is that second parent adoptions are essentially ironclad to create and maintain legal relationships for same-sex couples and their children. So every couple I see, whether it's estate planning or anything, I always ask, you know, have you done your second parent adoption? And if the answer is no, I explain why they should do it. It is fairly easy in Maryland with a new statute about 1.5 years ago. So that's just a sort of a practice tip that you really ought to be looking at and make sure you do that. I talked to an estate planning attorney the other day and she also, she's a good attorney, and she said, well, you know, they're married, so I didn't think we had to do anything. Well, no, you have to do something. Let me tell you about a couple of cases I've had trying to establish de facto parent. This was, I had two grandparent cases in Montgomery County where one of the parents, the wife, had died of a drug overdose, and the grandparents were basically acting in her shoes, and so the kids were half the time with them and half the time with the father. And unfortunately, I mean, we litigated it because the father decided on his own to stop their relationship with the grandchildren. And, you know, it was devastating, of course, for the grandchildren. So we litigated it in Montgomery County, and this was probably 5-6 years ago when things were still developing. And the court said, no, we had not established a de facto parent. And this was where they lived with the kids half time. They financially supported them. They worked in the school where the kids were. I mean, I think it was wrongly decided, but there wasn't anything really we could do. The other case, similar, grandparents, where the mother, unfortunately, was an addict, and she was sort of in and out of the children's lives and in and out of the grandparents' home. It was a very similar situation, and again, the court said, nope, this was not sufficient to prove de facto parent. There have been a couple of cases where step-parents, for example, and there's a case fairly recently in the Maryland court with this step-parent. They've been together for, you know, quite a while and then no longer together. And there was a mother, a legal mother. It's a very interesting case because it went a little further and it said, you know, could one parent essentially consent and create a de facto relationship with children without the other parent's consent? This case, and we'll put these up, EN versus TR. There were two legal parents. The step parent and the father were together for quite a while. Father goes to jail, and stepmom wants to keep seeing the kids and taking care of the kids, and he consented basically to her having custody, and the legal mom, the birth mom, challenged that. And the court came out with a decision, the Court of Special Appeals, saying that yes, stepmom is a de facto parent, and which is very important, that the stepmom's de facto parent relationship could be created solely by the father's consent, without the legal mother's consent. You know, which is interesting and raises probably all sorts of constitutional issues, but the court looked at the de facto parent elements from Conover and said, yes, she meets these elements, therefore she's a de facto parent. I think it's an interesting case. I had a case maybe 4 years ago where three people were in an intimate triad, throuple, if you will. And so a man and woman in that relationship were married, and they had a child together. But there was also another woman in the relationship with both of them, who of course was not married and had no legal relationships to them. And she and the husband had a child together. So the three of them were raising these two children. I looked at the de facto parent statute and said, it absolutely applies, right? It absolutely applies. All the four elements are met, everybody consents. We had this case in Anne Arundel County. I even brought grandma with us to be a witness, and I won't name the judge, but she was so hostile, really on a religious basis, I think, and didn't even really look at the elements of this, and screaming at the clients about, you know, do you know that these children can be taken away? Blah, 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 blah. It was so bad that I dismissed the case. And, you know, this is when I think de facto parent was still being developed, certainly before the most recent EN case. I think now, probably in front of a different judge, they would obtain de facto parent relationship for the two women. They would each be a de facto parent to the other woman's child, which would ensure their relationship should these three people stop being together. And that's really no different than having two people together. It can always happen, right? I mean, even if you have a biological child with someone, you always run the risk of losing custody or visitation or whatever. So the three of them, it was really no different, I think. So those, oops, here's Sarah, hold on.
Yes, hello. This is really helpful so far. Thank you. We've had a few questions come in. Hope you're able to hear me.
I can hardly hear you.
Sorry, I'm a little too quiet today. I'm sorry about that. Can you give us the case citation for the step parent case? Someone's interested in that?
Yeah, I was going to have Sarah put it in the
yes,
whatever that's called, but it's right. EN versus TR, August 25th, 2020. I don't have the actual site because what I'm reading from is from before.
It's no problem. I'm going to look that up and I'll put that in the questions box shortly. Yes. And a couple other questions. Going back to the court order. So I know I've never personally seen a court order in a de facto parent case. And you mentioned there's usually a finding, a specific finding. John Smith is a de facto parent. Can you tell us a little more about what the finding should look like? Have you ever had any problems with courts making it? Do some judges kind of Are they reluctant, or is there any practice tips around making sure that finding is correct and in the order?
You know, it's an interesting question, I think, because as we all know, every judge is different. And so every judge approaches this in his or her own way. I think a finding of de facto parent really has to go through the elements of Conover and establish each element by evidence, okay? Because the other thing you want, of course, is to protect your court order from appeal. So you want a judge to put the evidence in, because the trier of fact is essentially given free rein. Generally, a court is not going to, Court of Appeals is not going to overturn that. So I would say every element and evidence for every element, and then of course the conclusion is, therefore, so-and-so is a de facto parent of names of children and has the same standing and same legitimacy as a de jure parent, and name all the parties and all of that. I think that's probably the best you can do. I mean, I'll admit I've actually never had finally gotten a court order. The case I had with the 3 parents, I had prepared the court order, but we never got there. But those are the things. I think you want to make it as tight as possible and as evidentiary based as possible.
That makes sense. Thank you. And then the other question, let's see. I wrote down another question here, but maybe I will make sure I can read my handwriting and we'll move forward for now.
Okay, all right. I have to say, everybody, it's totally weird doing this because the only thing I see on my screen is me. So these things are always so interesting. So this notion of de facto parent is not limited to Maryland by any means. DC, where I also practice, actually has a statute. It's a de facto parent statute which incorporates many of the same elements of Conover. And I think you might want to look at that. I'm sorry, we'll put up the citation at 16-909 or something like that in the DC code. But it's interesting because here's Sarah again. Question?
Take your time, but we do have a couple more questions that have come in. In the event that the parents are minors, does that change anything about the de facto parent analysis?
I have never come up against that. I think it's an interesting question, but I think when minors have children, I think, based on other cases I've dealt with, like consent to an adoption or guardianship or something like that, either they're going to have a guardian appointed for them, right? Or they're going to be treated as adults. I don't think parents come into this in terms of being able to make decisions, because parents have other interests at stake here.
And I figured out my question that I had previously written down. There's a part in one of the elements of the de facto analysis about receiving compensation.
Right.
And I was wondering if you've had any experience with that, because when I try to talk to clients and figure out if they might have a de facto claim, sometimes they've received kinship care money or foster care money in the past. And,
right.
But there are also facts that suggest consent. It isn't just a random stranger receiving foster care or kinship care. It might be a sister, and maybe the biological parent or the legal parent said, sister, can you please take care of my children when I pass away from being ill? And then they pass away. So there is more of a parental role rather than just an average foster parent.
Yeah, I think what that compensation element is really talking about is you're not the nanny. You're not a caregiver who's getting paid for doing the care of the children. I mean, if you're getting foster care money, that money, at least theoretically, is supposed to be for the benefit of the children, right? It's not paying you for taking care of the children. So that's the distinction I think that this is trying to make, because in the past, when people were arguing, well, then anybody can be a parent, right? The nanny can be a parent. No, the nanny can't be a parent because the nanny is performing a job and getting paid for it. So I think what this element is really addressing is that this is not your job. This is your love. This is not your job. So I hope that
That
answers the
helps.
question.
Yeah, that makes sense. Thank you.
Okay. Keep going?
Yes, good to
Okay.
keep going.
I see myself again, so I guess I keep going. So the DC statute, and there are similar statutes in Delaware, Maine, sets out, exactly these elements. There's an interesting issue, I think, here about presumptive parents, because in the DC statute, if people are married or domestic partners under the DC statute, and they have a child together, there will be a presumption, a marital presumption, for 2 years that could be rebutted, and then it becomes an irrebuttable presumption. There's also another piece in the DC statute with if somebody, two people have children together and they consent to raise the child together, the non-birth parent is a parent, period, no presumptions. Maryland has a similar statute, the new statute about second parent adoptions that was passed, I think, last July 2019 or June 2019, also says if two people consent to raise a child together, they can do the second parent adoption. That new law has a bit of a twist in that even if they're married, they must obtain the consent of a known donor or show that they've used sperm from an unknown donor. The DC statute, so there's going to be a presumption that the couple are both legal parents, but for a de facto parent, it's very similar to Conover, and it's routinely used to prove parentage. From what I understand, that's the same in Maine, same in Delaware, so that the Conover elements, which really were taken from other cases around the country, have become embedded in the statute. And so it's, I think, in a way easier because you're just looking at the statute. I mean, presumably now we have a long-time case or a case that's not going to be overturned by the Court of Appeals again, so that we have de facto parent. And I think it was a recognition by the Court of Appeals that the relationships in families and the way families are constructed has really changed in the last, say, 12 years since Janice M. And so it was a recognition that that's the case. I think you're going to see more and more expansion under the de facto parent elements. I do a lot of training of judges, and a couple years ago, we talked about Conover, and I actually gave the judges, these were circuit court judges in Maryland, the facts of my 3-person family, 3-adult family. And to a person, every judge says, I will grant that. I would grant that. So we were just, unfortunately, we pulled somebody who wouldn't. But I think where we're going to start to have issues like this case that says one parent can consent and the other parent doesn't have to know about it. In that case, the other parent actually challenged it and the court said, nope, this is a de facto parent. So I think you're going to see sort of more and more about that, more and more like that. If you've got 2 people raising a child and it seems like all the elements are met, and then those 2 people break up, the person who is the legal parent is going to say, I never consented, I don't consent now, all these other things, and those are factual determinations that are going to have to be made. And unfortunately, as all of us family law practitioners know, that's pretty much going to be a judge by judge decision. And so what does that mean for filing your case? I also wanted to tell you about some resources for you to look at. The absolute best resource in the country is the National Center for Lesbian Rights. They're in San Francisco. They have quite a few documents talking about parentage, de facto parent, second parent adoption, whatever. And it's a wonderful, wonderful resource. You should go there. You can download their paper on parentage that will give you, I think, a lot of the ideas that lawyers are using all around the country. Because what's happening is that more and more the idea of parents is being expanded. You can be a parent. For example, I did some years ago in DC, I did an adoption of a man who was 35 years old. His aunt had raised him, and they just sort of never did anything about it legally, and somehow they came to the decision, well, it was time. Now, if something had happened when he was much younger and they had never done an adoption, perhaps they would have relied on the de facto parent. I have a case right now where a young man is 19, somebody who raised him, and they never did anything to legitimize that relationship. Now we're going to do a second parent adoption, but obviously had something happen during the course of his minority, the really de facto parent would have relied on a de facto parent statute or the elements from Conover. Sarah. Okay, there you are.
Sorry, a few technical difficulties here. Okay. I think you've touched on this a few times, but I just found it really helpful to hear about the different types of evidentiary kind of investigation and fact investigation you can do to prep these cases. And sure. I thought it was really interesting how you were saying, we're always focused on our client and what kinds of emails, Mother's Day cards, other things we can get for communication, to show that the parties both kind of believe this was a parental relationship. But I was wondering if you had any other thoughts or any other experiences of fact investigation, maybe of other parties, or does school or any other kind of doctors ever play a role?
Yes, absolutely. I mean, again, let me just go with two women raising a child because it's sort of the easiest example. They were not married. That's important because there's no marital presumption. And they never did a second parent adoption. So the non-birth mom, the non-legal mom, has no legal relationship to the child. Child's born. They send out birth announcements. Oh, and guess what? The child has the non-birth mom's name, last name. There are all sorts of congratulations. The two of you are going to be great parents, things like that. School. The non-birth mom goes to PTA, goes to all the school things. And, I'll just use my own life to give you an example. My daughter was born in 1985. It's hard to imagine that I have a child who's going to be 36. And to me, I was the birth mom and my then lesbian partner. In 1985, there was absolutely nothing we could do to create legal relationships for my then partner, except for estate planning, which I always tell people to do anyway, because you can name a guardian and do all those things. But there wasn't anything we can do, right? And so we broke up when my daughter was 5. In the interim, every time there was a school thing, we both went. We put out an announcement. We got all sorts of congratulations cards. We appeared in Christmas cards as a family. We didn't go to church, but my daughter was in Hebrew school. And both of us would go to the events. Both of us went to the events at school. All these kinds of things. So those are all factual facts that you would look at. Now, when we broke up, I could have said because there was no legal relationship, there was no such thing as de facto parent back then, I could have said, too bad, so sad, you don't get to see her anymore, right? She's 5 years old. Of course I did not do that, because what would that mean to her? You know, and unfortunately, a lot of people, when they break up, they don't think about their children. I had a case where a woman raised the child for 10 years. The kid was 10 years old when they broke up, and the birth mom refused to let my client see the kid. It was horrible, horrible. But anyway, so those are the kinds of things you're going to look to. Did you all go to the family events together? You know, we went to the family Christmas together on her side. So anything you would look at, I think, for a divorce, like who's really parenting, you would look at to prove a de facto parent. And, you know, I think it's a little hard to say you're non-legal mom, you're not a parent, even though the child has your last name, even though we sent out announcements about the birth of this child, even though we always went to your family for Christmas. You know, what are we talking about here? Unfortunately, though, I like that judge, there are going to be judges who say that's not enough. What if you're not called mother? You're called Sue. Does that make you not a parent? Of course not. It is your relationship with the child. But there are judges out there who are going to say, you know, you were never a mommy. That person didn't think of you as a mommy. So you have to overcome these kinds of stereotypes and assumptions. And some judges are going to go there, and I think there are, you know, a few who just aren't going to go there. That's why you need to put as much evidence in as you can, and then if your client, you lose and you have the wherewithal to appeal, you can do that, and then the record would be full of all this stuff. I mean, the case I had, there was no way I was going to spend my client's money, because it was very clear to me that this judge was never going to grant a de facto parent relationship, never. But I think what I should have done, and at the time, I don't know, I should have asked her to recuse herself, and I should have reported her. If I had it to do all over again, I would have.
It does sound like it is family law. So this is always the case to some degree, but in this area, you know, the biases and beliefs of the judge really play a role. So that is definitely something that's hard to contend with. We did have one other question come in. Thanks everyone for the great questions today. Feel free to ask if you have a question. This one is, okay, I'll just read it and we can see if we need clarification. How does it interact with paternity cases, best interest of the child, and who is financially responsible, or things like inheritance?
Well, so let me start with inheritance. I have not yet seen a case where somebody as a de facto parent dies and there's no will. Will the child inherit? I don't know the answer to that. I think they should, because they're supposed to be on the same legal standing as a legal parent. But I don't think we've seen that case yet. You know, paternity, all those other things, I think are probably irrelevant, because what you have to look at are the 4 elements under Conover, right? And you're going to prove those through the relationship of the child with the parent. You're not asking for a court to determine paternity. You're not. This is a totally different animal. You're not asking a court at that point to determine custody or visitation. The first hurdle is you've got to get this person to be a de facto parent. Then you work out the custody and the visitation. Now, a number of judges I've spoken to said they sort of do it all together. You know, they're going to hear all the evidence, look at all of it, and then say, yes, you're a de facto parent, and yes, based on the evidence, I'm giving you custody or visitation or whatever it is, so that you don't have to have, you know, 2 separate trials basically with the same evidence. So does that answer the question?
I think so. And if anyone else has follow-up questions about that, just put it in the question box. Thank you.
Yeah. Do you have another one?
I don't think we do at this time. Nope.
Okay. Okay. So I'll just ramble on.
Great.
So again, all of those of you who do family law, you know, just among us lawyers, we try to psych out the various judges. And if this is terrible, but if you can do that with a potential de facto parentage case, you need to, because exactly what Sarah said, that a judge's own biases and life experience, whatever, are really going to determine how the judge is able to see this family. As I told you, the case I had, the judge could not go there, could not see these three people as a family. You know, how you deal with that is certainly up to you. I am thinking very seriously about contacting these clients, assuming they're all still together. You never know, I suppose, with anybody. Taking this case on pro bono, because what happened was a travesty. It was completely wrong. So I'm not sure that I have a lot more to say. So yay, we have a question.
We do have a follow-up on that one. I think I'm beginning to grasp it. So let me try to paraphrase. I think when you are seeking child support on behalf of a client in this situation, would you seek it from the biological parents as a de facto parent, or would one biological parent seek support from the other parent and a de facto parent?
You know, it's a very interesting way to look at this, because certainly not only have legal parents, often birth parents, prevented other parents from seeing a child, there have been cases where somebody has raised a child and, you know, let's just say person's a de facto parent, there's no question, but there's no legal relationship. Can the birth mother go after the other person after they've separated for child support? And I think absolutely. Why not? You go in, you still have to prove these four elements. You have to prove the person's de facto parent. De facto parent is supposed to have all the same rights and responsibilities as a legal parent. So that not only includes custody and visitation, it includes child support. I had an interesting case years ago. It's similar to this. It's not a de facto parent case, but I was representing these two women. They told me they lived in Maryland. They had a little girl, and we were going to do a second parent adoption in Maryland. Okay. Sort of, for me, run of the mill. I happened to, I don't know why, but I happened to have their documents in my car, and I needed them to sign it. And I was in the neighborhood where they said they lived, so I went to their house. And I'm looking around because it doesn't look like a kid lives there. And a neighbor comes out and says, "Who are you looking for?" And I said, "You know, I'm looking for these clients." And he said, "They don't live here." And I said, "What? No, they don't live here." So I confronted my clients. Well, it turned out they lived in Virginia. And that was back in the days where we could not do Virginia adoptions. And it was also pre-marriage equality. And, you know, when they came to see me, the non-birth mom just went on and how her partner and the child were her sun, moon, and stars and loved them to pieces. Well, I obviously didn't do the adoption, and like an idiot, I gave them all their money back, but okay. I find out later they break up and the non-birth mom disappears after raising a child for 4 or 5 years. No child support, nothing. So there's that other side. It happens.
Yeah, that's an interesting side to it, you know, the responsibilities and not just the good parts of, you know, being a parent.
Right.
I mean, it's all very important to the well-being of the children. So
Yep.
That's an interesting point.
Yeah, it is most often the other way around, but the child support is definitely an issue.
Yeah, that's helpful to think about that way. All right, I'm not seeing any other questions. If you have some, let us know. I'm going to throw some slides up here about MVLS in case anyone wants some more information, and I'll run through these. Thank you so much today for this training. It's been really valuable. Really glad our attorneys had a chance to learn some more about these issues. And I'm not seeing any questions, so I think we will go ahead and close for now. And thank you all for your time today.
And thank you, everybody, for doing this kind of work. It's important.
Absolutely.